We are now here for a non-compliance tow hearing for Dahlia Ehrenberg versus Stoneleigh Condos. Do I have someone here on behalf of the plaintiff and Ms. Ehrenberg?
Hi, yes, it's me.
Good morning. Thank you for being here.
Good morning.
Who do I have on behalf of Stoneleigh?
That would be me.
Tell me your first and last name, sir.
Jonathan Dickinson. Jonathan Dickinson?
Dickinson. Thank you. All right. Let me go ahead and ask all parties. I know we have someone on behalf of the tow company. Ms. Mora, you're here with the record. If we have anyone from Reliant or anyone else, if you're going to be testifying or offering me information, I'd like to swear all the parties in. So if you would please raise your right hand. And do you understand that by appearing in court and offering testimony, you are swearing or affirming to tell the truth, the whole truth, and nothing but the truth under a penalty of perjury? Do you so swear?
Yes, Your Honor.
All right. All right. Ms. Ehrenberg, good morning.
Good morning.
All right. What day was your vehicle towed?
It was towed on October 13th, 2025.
Right. And where was the vehicle parked?
It was parked at Stoneleigh condominiums in the designated visitor parking area.
Do you live at this location?
No, I was an invited guest.
What time did you discover your vehicle had been towed?
It was around, I want to say 10:45 p.m.
On what day?
on 10/13.
This hearing begins as a formal non-compliance to dispute between Dahlia Ehrenberg and Stoneleigh condominiums. From the outset, the court establishes procedure, identifies the parties, and ensures all participants understand the seriousness of sworn testimony. Every word spoken from this point forward carries legal weight under penalty of perjury. The judge's tone is calm but precise, signaling that this case will be decided on facts, not emotions. Before any argument is heard, the court secures the foundation of credibility. In courtroom proceedings like this, truth is not assumed, it must be demonstrated.
Okay, so the same day.
Yes.
When had you parked your car there?
Ooh, probably around 4 p.m.
On what day?
on 10/13.
Are there any posted signs or warnings or information there about visitor parking?
Yes, there are.
What do they say?
So in front of the spot, it says visitor parking, visitors must register to park, and it has the URL.
And did you register your vehicle?
I attempted, but the system was not working.
So the answer is no, you did not register.
I did not register.
Did you notify the person you were visiting that you couldn't register your car?
Yes, I did.
What'd you do then?
He had emailed them previously that the registration system wasn't working and hadn't received a resolution.
So did you just choose to go ahead?
Ms. Ehrenberg testifies that her vehicle was towed on 13th October 2025 while parked in designated visitor parking at Stoneleigh condominiums. She confirms she does not live at the property and was present only as an invited guest. The timeline becomes critical. Parking occurred around 4 p.m. and the tow was discovered at approximately 10:45 p.m. the same evening. These details matter, as towing legality often hinges on notice, signage, and duration. At this stage, the court is establishing the uncontested facts before examining responsibility.
And park without it?
Yes, because they had recently changed their parking system, so we understood that they were aware that there were issues with the new parking system. Therefore, I had been parking there. I hadn't received any kind of warning or anything, so we just assumed that they were aware of the issues.
Yeah, Ms. Ehrenberg, just so I'm getting it straight. You knew you needed to register, but you weren't able to do it. And because you hadn't been towed before, you thought, they're not enforcing it, and you just took a risk.
Right,
So you parked without registering, even though it says you must register.
yes.
Had the person you visited received anything from the landlord that said, we don't need this anymore, we're waiving it?
No,
And this time you got towed.
yes.
Why do you believe you were wrongfully towed then?
Because I made every effort to register, the system just wasn't working, so
Did
I
you
had
have
no
parked
way to
off-site?
register. What was that?
Did you have parked off-site and had your friend come pick you up?
The judge now turns to posted signage and parking rules. Visitor parking, while available, comes with conditions, specifically mandatory vehicle registration through an online system. Ms. Aronburg admits she saw the sign and attempted to comply, but claims the registration system was not functioning. Importantly, she confirms that despite knowing registration was required, she parked anyway. This admission becomes pivotal. In court, intent matters less than compliance. Even good faith efforts must still align with written policy, especially when enforcement mechanisms like towing are clearly disclosed.
Bring you back?
Yeah, I suppose that was an option.
Mhm. What's the theory for why you were wrongfully towed, Ms. Ehrenberg?
What was that?
Why do you believe you were wrongfully towed?
Because we notified them of the issues with their system and we didn't receive a resolution. And I had no way to register. So there really was, I made every like good faith attempt to register to parking. I would have received no benefit from not registering to park. But we just were unable to. So there was no way for me to register to park.
Do you have any records of you attempting to register that evening?
I don't know.
Do you have any proof that you've notified the landlord on previous occasions that the system didn't work?
Yes, I do have an email from the resident that was sent to the HOA. And I sent that in.
Let's see.
The judge reframes the situation clearly. Ms. Aronburg knew registration was required, could not complete it, and chose to park regardless, hoping enforcement would not occur. This was, by her own admission, a calculated risk. The court emphasizes that assumptions about enforcement do not override posted rules. No written waiver existed. No official notice suspended the policy. The absence of prior towing does not create permission. This moment underscores a core legal principle: compliance is not optional simply because enforcement seems inconsistent.
I got 22 pages. We'll take a look. I'm looking briefly through these. I want to make sure I'm not trying to share a whole lot of personal information. That is a lot of emails. Is Nick
Nick Papanastasio.
Papanastasio. Okay, is that the person you're visiting?
Yes, ma'am.
I'm just going to click through these with everyone. So, Mr. Dickinson, I'm going to share my screen. These were marked as plaintiff's exhibits, okay? Okay, so I see there's a Nick over here, email address submitted, last updated. These are all on October 17th. So these are 4 days after the tow happened. So this is not in advance. Let's see. This is 4 days later. That's not doing me anything. October 13th, 9:30 p.m. This is from the wrecker service that they're towing it. That's not doing anything. Okay. Ms. Ehrenberg, is this your vehicle?
Your Honor, nothing's sharing.
All right.
Attention shifts to documentation. The plaintiff claims prior notification to the HOA regarding system failures, but the evidence tells a different story. Emails submitted largely post-date the tow or relate to resident registration, not guest access. The judge carefully examines timestamps, sender identities, and relevance. Courts rely on contemporaneous proof, not retrospective explanations. While the volume of emails appears substantial, substance matters more than quantity. Without clear evidence showing the system was non-functional at the exact time of the tow, the argument weakens significantly.
Yes.
You know, if the registration problem was causing problems for guests to be able to register their vehicles?
No, not for the site. The only issues we saw is that if a resident was not registered with a vehicle, then their visitors could not register.
Do you know if the person she was visiting, was he registered?
At the time of their email, no, they were still not registered.
How about on October 13th when she was towed? Was the friend she was visiting registered then?
No.
Ms. Ehrenberg, it sounds like the reason you couldn't register is Mr. Dickinson is saying that the friend you were visiting, he had not completed his registration.
Okay.
Okay. Sir, I understand that's difficult. Certainly it was probably no fun and a lot of money, but I don't find that it was an improper tow. There was authorization, there was notification, and maybe check with your friend just to see if he actually is registered, because it essentially, you know, I don't know the situation, but he might be liable for a tow. Okay, ma'am? Very good luck to you, Ms. Ehrenberg. Thank you for coming. Thank you for pursuing it. I hope that's informative. Even if it's not a fun answer, I hope there is.
The court highlights a critical clause in the parking agreement: visitor parking is a privilege, not a right. This distinction is decisive. Property owners are not legally required to provide guest parking at all. Conditions may be imposed, changed, or revoked entirely. The judge explains that compliance with registration rules is mandatory, regardless of inconvenience. Even if alternative transportation options are inconvenient, they remain lawful alternatives. This clarification reframes the issue from fairness to legality, and legality is the court's sole concern.